So we're going to transition to our afternoon programming with Thomas, Alan, and Linzey. And he will have a presentation, and then he will be inviting on his panel members to discuss the rights-based protections for nature. Welcome, Thomas.
Thank you, Maida. As Maida said, I'm Tom Linzey. I'm an attorney with the Center for Democratic and Environmental Rights. And at the outset, I just wanted to give a big thank you, a shout out. Grateful for Randy and Maida and the tech folks who have made all this, made this event happen and made it possible. I'm sure they're tired of my emails at this point about the tech stuff, but so I appreciate their patience. So we have a lot to talk about today, rights of nature, so let's roll with it. So at the outset, I just wanted to cover some of what's been done by tribes in the United States around rights of nature. So on September 26, 2016, the General Counsel of the Ho-Chunk tribe in Wisconsin voted to amend their tribal constitution to establish the rights of ecosystems to exist and thrive. The amendment then banned frac sand mining, fossil fuel extraction, and the use of genetically modified seeds as a violation of those rights of nature recognized within the amendment. On December 31st, 2018, the Business Committee of the White Earth Ojibwe Nation in Minnesota legally recognized the rights of wild rice, or Menominee, to exist, flourish, regenerate, and naturally evolve. They then banned the patenting of the rice and genetic drift from genetically modified crops as violations of those rights. On May 9th, 2019, the Yurok Tribal Council adopted a resolution establishing the rights of the Klamath River to exist, flourish, and naturally evolve, and banned all projects that would violate those rights. And finally, on January 16th, 2020, just this year, the Menominee tribe in Wisconsin recognized the rights of the Menominee River to exist, flourish, regenerate, and evolve, and recognized a right to natural water flow for the Menominee River. So with all that being said and people learning about what tribes have been doing with rights of nature work, speaking to a colleague last week, an attorney colleague, she asked, after she had learned about these developments, what's going on with these laws? What do they mean? And as I told her then, I think that the laws are really a development, the emergence of people that have grown tired with trying to make conventional environmental laws work for them. And I know that we're tired. For 10 years, as a public interest lawyer working mostly with community groups and municipal governments, we too struggled to enforce the Clean Air Act, the Clean Water Act, the National Environmental Policy Act. And at the end of those 10 long years, the only honest conclusion that I could draw was that the system is rigged from the start. That system has us chasing permits, which legalize mines, incinerators, fracking, begging government agency officials to do the right thing and not issue permits for these operations, arguing to judges that permits were wrongly issued, haggling over parts per million, maximum daily loads, and dissolved oxygen levels, which is all lawyer and scientific speak and lingo that most people don't even understand what those terms mean. It diverts us, this environmental regulatory system, into talking more about how to allow these projects that we know will be harmful to our communities, rather than talking about whether to allow them at all. And it has us celebrating temporary victories that rarely translate into permanent ones that actually protect our own communities. In the end, it seems we become enforcers of regulations written by the very industries that ostensibly are regulated by those regulations. And as somebody said a couple of years ago, somebody much smarter than I was at the time working on the environmental regulatory system, she said that the only thing that environmental regulations regulate is us, because they make us predictable as to how we respond when projects are proposed, because we're working under a script that's been written for us by someone else when we defend our communities against these projects. A lot of folks have said, enough with participating in this environmental regulatory system that in most cases were superimposed, the system was superimposed on the communities that we're working to protect. It should come as no surprise that while we're busy playing a version of the game whack-a-mole, we stop one project or try to stop one project and 3 more come up, that by almost every major environmental statistic, things are worse today than before the major environmental laws were passed 40 some years ago. In our journey working within the system as public interest environmental lawyers, it forced us to look at the bedrock of our environmental regulatory system and at the way that Western law treats nature. So how the Western system of law actually treats nature, because our environmental regulatory system arises from that Western system of law. I think that view was perhaps best summarized by Sir Francis Bacon. He's an English philosopher. We don't read Bacon every day, but famous English philosopher who once described humanity's duty and responsibility to, quote, torture nature on a rack to extract her secrets. So English philosopher, English system of law morphed into our Western system of law. Torture nature on a rack to extract her secrets. Instead of viewing nature as a living entity or as a relative, Western law, as we all know, and I'm not saying much that we don't know at this point, treats nature as a thing or as property whose exploitation is assumed, and that the best we can do is regulate the rate at which we exploit nature, to regulate the rate at which we destroy nature. So after working in the environmental regulatory field for a little over 10 years, from 1995 to 2005, a little after that, we began personally to re-examine this Western system of law and the environmental regulatory system which it has birthed. And we ran into a law professor from the University of Southern California who wrote back in 1972, and he's still around teaching. His name is Christopher Stone. That finally a living view of nature, kind of an indigenous view of nature as animate and living, finally emerged into Western thought in the US back in 1972. And that's when a law professor named Christopher Stone wrote a law review article called Should Trees Have Standing? And folks probably know what standing is, but it's about having injury to get into court. And Christopher Stone's article was so audacious to say that ecosystems, forests, mountains, rivers, oceans should actually have access to the courts themselves through people speaking on their behalf, almost as trustees or representatives. But that ecosystems or nature itself should have access to the courts to stop those projects which threaten to harm those ecosystems or nature. And Christopher Stone came up with this concept during a sleepy law school class after lunch to try to re-energize the students and get a conversation going, because it was very controversial at the time. That conversation then turned into a law review article entitled, again, Should Trees Have Standing? And it happened that the law review article in 1972 came out at a perfect time, kind of a perfect storm, which is in front of the U.S. Supreme Court at the time, as the law review article came out, was a case known as Sierra Club versus Morton. And the case name is unimportant, except to say that the Walt Disney Company wanted to develop Mineral King Valley in California. And so the Sierra Nevada mountains east of San Francisco, over on the border, eastern border of California, they wanted to develop a ski resort. And that ski resort was slated to bring in 1.7 million visitors. About 20,000 skiers. So think in terms of scope, bigger than Disneyland, this project that they wanted to put in what is now Sequoia National Forest in the Sierra Nevada mountains. The Sierra Club environmental group filed a lawsuit to try to stop the Secretary of Interior from issuing a permit to actually put that proposed project in. Sierra Club sued. The lower courts dismissed the case because of lack of standing. So holding that the Sierra Club couldn't show that they had been injured or harmed enough to actually get into court to argue on behalf of the ecosystem for its protection. Goes all the way up to the U.S. Supreme Court. The U.S. Supreme Court affirms the lower court, throws the Sierra Club out, says you don't have standing to testify or argue in front of the defense or for the defense of this ecosystem. And Justice William O. Douglas, probably one of the most progressive justices that we've had on the U.S. Supreme Court, took Christopher Stone's piece, Should Trees Have Standing, and actually converted it into a dissenting opinion. A dissenting opinion that we will probably not read the likes of in the next 40 years or longer. But he wrote a dissenting opinion based entirely almost on Christopher Stone's article, Should Trees Have Standing. I just wanted to read a paragraph of what he wrote in that dissent. And again, dissenting opinion, Sierra Club versus Morton, U.S. Supreme Case, 1972. This is Justice Douglas's quote. He wrote, "The critical question of standing would be simplified and also put neatly in focus if we fashioned a federal rule that allowed environmental issues to be litigated before federal agencies or federal courts in the name of the inanimate object about to be despoiled, defaced, or invaded by roads and bulldozers, and where injury is the subject of public outrage." And then he talked about human standing, the ability of people, persons, human beings to actually enter the court and make a case. He says, "So it should be as respects valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, groves of trees, swampland, or even air that feels the destructive pressures of modern technology and modern life. The river as plaintiff speaks for the ecological unit of life that is part of it." So kind of an entry point for indigenous values. Nature is living, nature is animated, rather than this Western system of law that treats nature as dead, as a dead thing whose use needs to be regulated by the law. So what happened next in this chronology? Well, in 1972, the opinion came out. Some lawyers tried to use it to sue on behalf of various animals or ecosystems. You had a couple cases in Florida where key deer, the key deer population were a plaintiff. Loggerhead turtles were plaintiffs. A couple other states where those kinds of cases were brought. Most of them were dismissed because the courts held, of course, silly people. Courts are for people, not for animals, not for ecosystems, not for nature. And it kind of stalled in the 70s in that place. We picked it up again back in 2006 with a little community called Tamaqua Borough. And just to tell a short little story here about Tamaqua Borough, it's a town of 7,000 people northwest of Philadelphia. It's a big mining town for the past 150 years. And in the borough of Tamaqua, they have these open mine pits where mining had been done for coal in the past 150 years. The EPA and the governors of Delaware and Pennsylvania came together and said, wow, those mine pits would be a great place for PCB-laden dredge that we're going to be taking out of the Delaware River, and we need to dump somewhere. So the folks of Tamaqua Borough, and of course other communities who are targeted with these types of projects, said, we don't really like the idea of us becoming a toilet to this PCB-laden dredge that's coming in. We want to stop it. And they came to us, and I helped them, assisted them with drafting local law that exercised their kind of municipal sovereignty to say no to this PCB-laden dredge coming in. In that conversation, developing that ordinance, that local law about the PCB dredge, we were approached by fishermen and other people that used the Little Schuylkill River, which provides Philadelphia's drinking water, the Wabash, Panther Creeks, different waterways that ran through Tamaqua Borough. And they said to us, surely there's got to be a better way to protect these waterways than under the Clean Air Act or the Clean Water Act or the Clean Streams Law, laws in Pennsylvania and federally, of course, that allow certain kinds of intervention on behalf of waterways, but they're usually after the fact, and they're kind of post-pollution. And so folks in the community, including trout fishermen, said to us, we want to develop a law that actually protects the rivers and creeks and actually allows us as residents of the community, as citizens of the community, to step into the shoes of those ecosystems to bring actions against those that would violate the rights of the river and the waterways within Tamaqua Borough. And so in 2006, we ended up helping them draft what became first in the world rights of nature law within Tamaqua Borough, a local municipal law that did three things. Number one, recognized that the waterways there had constitutional rights of sorts to exist, to flourish, to naturally evolve. That was the first piece of it. The second component was to recognize that residents of the community could step into the shoes of the Wabash Creek or Panther Creek or Little Schuylkill River and bring claims on behalf of those waterways against projects like the PCB laden dredge dumping that was scheduled to occur. And finally, the third piece was about what kind of remedy was available, restoration of the waterways to pre-violation state. So again, three elements. One, rights of the waterways. Two, the ability of people to step into their shoes, the shoes of the waterways, to defend those rights. And finally, remedy, or restoration as a remedy, to hold those violators accountable to actually revert or fix what they've caused through violating the local law. And in line with the topic of this presentation, which deals with tribal sovereignty, I've worked for a number of years on what we refer to as municipal sovereignty, so that municipalities have power to pass heightened environmental standards above that provided by the state or federal government. That there's a sovereignty aspect to these laws as well, which is extra jurisdictional. So we usually think about local laws being passed can only be enforced on the reservation, can only be enforced within the municipality where we've passed them. But these laws are about reaching outside the municipality, saying that there are actions outside of the municipality or outside of tribal land, outside of reservation boundaries, that may affect or violate the rights of the waterways or ecosystems within the municipal or tribal boundaries. And therefore, an action should be able to be brought outside of those boundaries to actually stop those things from happening. Similar to human rights, where if we have human rights within a certain territory, that actions that happen outside that violate those rights should be actionable as well. So that was the story of Tamaqua, the first place in the world to pass one of these rights of nature laws, Tamaqua Borough in Pennsylvania. And then we got a call from Ecuador, where the Ecuadorian Constitutional Assembly was beginning to meet. They had heard, a small world, but they had heard what had happened in this tiny little borough government in Pennsylvania. And they called us to come into Ecuador to assist them with drafting a new national constitution. And they wanted that national constitution to contain this rights of nature concept, to actually embed it within the federal or national constitution for the country of Ecuador. And so we went down and I spoke to the committees that were working on the national constitution. They decided to embed rights of nature language into the national constitution, then went out for ratification. Long story short, vast majority of the Ecuadorian public voted to put those new constitutional provisions in place, adopt a new constitution. And Ecuador was the first country in 2008, so 2 years after the Tamaqua law was passed, to adopt a rights-based system of environmental protection. So shifting from a property-based system of environmental protection to a rights-based system of environmental protection. And it wouldn't have happened except for the large indigenous community, the Achuar, the coalition of indigenous peoples in Ecuador who pushed for these provisions to make it into the Ecuadorian constitution. And so that was amazing. After it was passed, we looked for enforcement cases. There have been over 60 that have been brought to date on behalf of ecosystems in the country of Ecuador. The first one was a case called the Vilcabamba River versus the province of Loja. Case name is unimportant except to note the river is the plaintiff. And it takes a while to get our heads, brains kind of bend around that sometimes. But in these cases, the ecosystem, nature, the natural community is the plaintiff in these cases. So it looks at harm caused to the plaintiff, what remedies can be given out that fix the plaintiff, but it's all from an ecosystem or nature point of view. So what happened next after Ecuador? Ecuador, in a way, is a huge case study. Other countries have modeled their laws on what Ecuador has done around this rights of nature work. What was fascinating to us is that the work in Ecuador then boomeranged back to the United States. In 2010, the city of Pittsburgh, Pennsylvania, became probably the most well-known municipality in the United States, certainly the biggest municipality in the United States, to adopt a rights of nature law, specifically to protect the Ohio, Allegheny, and Monongahela rivers in the city of Pittsburgh. So Pittsburgh Steelers fans, Three Rivers Stadium, the three rivers that run through the city of Pittsburgh being impacted by frack chemicals being dumped in the water. The city council in the city of Pittsburgh was also presented with a proposal by a corporation to try to frack for natural gas underneath the Catholic cemetery within downtown Pittsburgh. So fracking companies coming in and wanting to drill through the Catholic cemeteries in the middle of Pittsburgh to access the gas reserves underneath the city. The city asked us to draft a law that would ban fracking within city boundaries, which we did. And then they also wanted us to incorporate this concept of rights of waterways, and specifically rights of Three Rivers, into this ordinance to be considered by the city council. Still amazing to say it, but the city council voted unanimously to adopt a rights of nature law, which wrote on top of this fracking ban within the city of Pittsburgh, and is still law today. Also in Pennsylvania, several small townships that were trying to stop frack wastewater injection wells. So when we think of fracking, it's all that wastewater, which is sometimes radioactive, which comes up out of the ground, has to be disposed of somewhere. So mostly on the East Coast, it goes to Ohio, but some ends up in Pennsylvania. Two small communities targeted for frack wastewater injection wells said, we're not going to do that, and actually adopted an ordinance not only banning those frack wastewater injection wells, but also recognizing the rights of watersheds and streams, creeks, within those communities. And then as the lawsuit got underway, we made a motion to intervene on behalf of those townships and on behalf of those waterways and creeks into other cases. So in terms of enforcement, taking those rights of ecosystems, trying to use them in court. Folks may have heard about the Lake Erie Bill of Rights. City of Toledo passed overwhelmingly rights recognizing that Lake Erie, ordinance recognizing that Lake Erie had certain rights to exist and flourish. That comes on the heels of algae blooms that deprived over 500,000 people back in 2014 of their drinking water. So folks throwing off the environmental regulatory system, saying thank you very much, but we're going to do things differently here, and we're going to assert this municipal power that we have to expand, recognize, secure these kinds of rights for ecosystems, which allows us then to come in and actually defend those ecosystems on their own. So a bunch of international developments, and then coming back to tribal work to close up here. But amazing also to us has been that this concept of rights of nature has begun to move in countries where they have no legislation. So no constitutional provisions, no legislative framework, no laws in place passed by legislatures. Courts have begun to announce that they are recognizing rights of nature. First one was in 2016, the Colombian Constitutional Court, so a high constitutional court, high court in Colombia, recognizing the Rio Atrato River, which is threatened by mining and other kinds of extraction, as having rights. In 2017, a court in India recognized that the Ganges River was a legal person for purposes of having rights, so capable of holding rights and having rights as the Ganges River. In 2018, the Colombian Supreme Court recognized that the Amazon and Amazon River Basin was the subject of rights. So rights to exist, flourish, capable of holding rights, legal persons for purposes of appearing in court, a kind of an expansion of the work that had gone before. In 2019, the High Court of Bangladesh recognized the legal rights of all rivers in Bangladesh. So again, attributes of personhood, recognizing those rights for rivers in Bangladesh. And again, these courts making these decisions, resting on nothing else but that the rights of nature is an emerging norm of international environmental law. So looking at the Ecuador constitutional provisions, the work that had come before, judicial recognition of rights of nature without legislative platforms. And then one other thing to mention on the international front, Uganda passed the National Environmental Act last year, provides rights for all ecosystems. So legislation, not just in Ecuador, also in Bolivia, Uganda, starting to spread through those legal frameworks as well. So coming back to the U.S., I mentioned a couple tribes in the beginning that had done this work. The Ho-Chunk tribe in Wisconsin was the first to actually inject rights of nature into their tribal constitutional provisions, or take a first vote to do so. Their general membership still has to ratify that. That was 2015. The Ponca in Oklahoma, the Ojibwe, Chippewa, White Earth Nation in Minnesota around wild rice, so kind of a cultural use of rights of nature around Menominee. The Menominee tribe recognizing the rights of the Menominee River, and the Yurok tribal nation, Yurok Nation, recognizing the rights of the Klamath River, which happened just recently. And even more recently, just a couple of weeks ago, the Nez Perce, recognizing the rights of the Snake River in Idaho. So passed a resolution recognizing the rights of the Snake River in Idaho. Extremely important, and another expansion of kind of this rights to another major ecosystem. So just to finish out here with two things. One is that we think the most important environmental ballot initiative appearing this year on any ballot in the United States is happening in Orange County, Florida. And in Orange County, Florida, the county subunit agency of the county has put on the ballot an initiative that would recognize the rights of the Wekiva and Menikanaehk rivers and all waterways within Orange County. So think Orlando, that's in Orange County. And the reason why it's so important is not just because of the crisis of Florida waterways, which folks may have been paying attention, Biscayne Bay, 0 dissolved oxygen levels a couple of weeks ago, fish kill, dead life in Biscayne Bay. Even before COVID, people were wearing masks on the beach. There were backloaders picking up dead sea life, manatees and dolphins off the beaches. You have red tide, algae blooms, you name it. There's too many people living in Florida, so you have nutrient loading and all this other kind of stuff. A crisis in that county, a crisis in Florida in general, led to the placement of this initiative on the ballot, which would recognize rights of these rivers within Orange County. It's a huge ballot initiative because it's the largest place in the United States that will have ever adopted a rights of nature law. It's 1.4 million people in Orange County. It's the 30th largest county in the United States, 5th largest in Florida. And so Election Day will be very important for the recognition of those rights. And then folks are already talking about how to enforce those rights on behalf of the Wekiva and Menikanaehk rivers. So I know this is a relatively short amount of time to spend with folks. It's one of the reasons why we suggested having a workshop so that people that were more interested in this concept can dig into the details. And so the workshop that's coming next is basically about how to propose, draft, and adopt these rights of nature provisions within the tribal context. And I'm very excited that Geneva Thompson, who's the Associate General Counsel for the Yurok tribe, will be making a presentation. She can't be with us personally, but she taped her PowerPoint, and we're going to have that. And then Guy Reiter with the Menominee, he was the lead organizer with the resolution to protect the Menominee River. And both will be talking about challenges and obstacles, because there are plenty, not just to passing it, but also to enforcing it, and what the details look like. The devil's always in the details. But suffice it to say that folks like Geneva and Guy and the Yurok and the Menominee and other tribes are really embarking on a new voyage. And the new voyage is to leave this environmental regulatory system that speaks Greek to us in a much different language than the animated living system of nature that most of us know and love, and moving in a direction where our laws and our legal system and tribal constitutional provisions actually parallel our belief system, and that we're not thrust into this weird world of talking about maximum daily loads and dissolved oxygen and all this other stuff, that we actually are able to conform our laws to that belief system. So that's what they're going to be talking about in the workshop. And again, I really appreciate the time that has been given to me today to do this keynote, and hoping that folks find some value in the workshop to follow in terms of the details around proposing, drafting, and enforcing these rights of nature laws. Thank you.
Wonderful. Thank you, Thomas. I just wanted to jump in real quick because we don't have Guy on our comm yet. So maybe while you're playing the video, you can send him an email message and let him know that it's time.
Okay. Sounds
awesome.
good.
Thank you.
So, so Maida, are we ready to do the workshop then? Are we moving into that?
Yeah, if you're ready, go ahead and transition. If you need a few moments, I can tell bad jokes.
No, we're ready to move. So,
awesome.
So just jumping from the keynote to this particular workshop, the reason for the workshop was kind of hands-on so that people could ask questions about, how to draft these, how do they get enforced, what are some of the challenges and obstacles to those. And so, during the keynote and the work that we do, we talk about the deficiencies of environmental law. What doesn't it do? What is it lacking? How do we replace those things with these rights of nature laws? And again, as I said before, 36 municipalities across the United States, including the city of Pittsburgh, have passed these kinds of laws. You have countries that have put these national legislative pieces in place. You have courts that are now ruling that recognizing rights for nature is part of this emerging international norm of environmental law, so moving on their own. And then, of course, you have the tribes where it's expanding very quickly in terms of tribal use of these rights of nature laws. And as I covered before, these laws have those three parts: rights, enforcement of the rights, and then finally remedies that can be accorded by a court if you enforce those rights. And primarily this panel, this workshop, was intended to answer three questions: why, how, and what. And so what you'll see in Geneva's video, who comes first, she's going to do a very short 11-minute PowerPoint that really focuses in on those three questions about why, how, and what, and comes at it from a tribal sovereignty level as well, in terms of exercising jurisdiction over things that are happening outside of the ecosystem that affect those rights that have been recognized within the ecosystem. And so very happy to have Geneva at least appearing virtually through this taped PowerPoint. And just to introduce Geneva briefly, her full name is Geneva E.B. Thompson, and she's the Associate General Counsel for the Yurok Tribe's Office of the Tribal Attorney. She's a board member of the Native American Bar Association and a delegate to the American Bar Association. She is the primary author of the tribe's rights of the Klamath River Resolution, which we were happy to help contribute in a small way to the development of that resolution. So we're going to play her PowerPoint now.
Osio, Anahkwet, and hello. My name is Geneva E.B. Thompson. My preferred pronouns are she, her, hers. I'm a citizen of the Cherokee Nation and Associate General Counsel for the Yurok Tribe. I would like to first apologize that I cannot be on the panel with you in person, but I want to thank the panel organizers for allowing me the opportunity to pre-record my presentation so I could share a little bit with you about the Yurok Tribe's efforts to protect the Klamath River and implementing a legal framework to codify the rights of the Klamath River under Yurok law. So I'm excited for the opportunity to share this information with you all. So first and foremost, I just want to put a quick disclaimer out there that the Yurok Tribe is still going through its legislative process in implementing the rights of the Klamath River under Yurok law, and so we're still going through that codification process. And so you just want to put it out there that the statements and opinions presented today are subject to change as we gather more community feedback and work with our departments and tribal council to implement this law. It's a quick presentation outline. I'm going to go through and talk about why the Yurok Tribe is codifying the rights of the Klamath River, how the Yurok Tribe is implementing a legal framework for the rights of the Klamath River, and what is included in the new law. So first, why? So we start off with the Yurok worldview about protecting Yurok natural resources. And I think this is really based out of one of the founding documents that really explain the Yurok worldview and importance of Yurok natural resources comes from the Yurok Tribe's constitution, and specifically its preamble. So I provided language there for you all to see, but essentially the government was formed by the Yurok people not only to represent Yurok people and interests, but also to protect cultural and natural resources that the Yurok people rely on. And through its constitution, all laws created by the Yurok Tribal Council go back to this idea that the government is to serve the Yurok people and protect the Yurok people's resources. And so we really, when starting to think about the rights of nature and the rights of the Klamath River, we go back to that foundational government document to set the tone for all laws moving forward. So Weeroy, or the Klamath River, is a central life force for the Yurok people. The Yurok Reservation starts at the mouth of the river and goes up 45 miles and is 1 mile on either side of the river. So the river is literally central to the Yurok Reservation and central to the Yurok people's lifeways. And so when we were thinking about developing the rights of nature and what we wanted to do to strengthen tribal jurisdiction and strengthen the tribe's ability to protect its natural resources, it was made the most common sense to centralize this law around the Klamath River because of its significant cultural, ceremonial, religious, fisheries, subsistence economics, and residence features the river provides the Yurok people. And so it was kind of a no-brainer there to really think about what kind of laws we can put in place that would protect natural resources and really viewing the river as that cultural landscape. Another thing that the reason why we decided to create this law is because the importance of salmon to the Yurok people. And salmon use the Klamath River for their homes and for breeding purposes, and is the central way that the salmon connect with the Yurok people. So as you can see on the screen, here is some quick language from Susan Matson, who's a Yurok elder. If you want to see her full interview, I provided the link at the bottom. But she goes in and talks about how central salmon are to the Yurok people. And it's said that the salmon wouldn't exist without the Yurok people, just like the Yurok people would not exist without the salmon. And so a lot of my work at the Office of the Tribal Attorney is figuring out legal campaigns to protect the salmon and protect the water rights needed to support healthy salmon populations for the Yurok people. And so when we were thinking about the rights of the Klamath River law, it was very important that we had to link salmon, the Yurok people and the river all together, and how they all help define that cultural landscape. So how are we implementing this new law? First, the Yurok Tribal Council passed Resolution 1940 on May 9th, 2019, which declared the rights of the Klamath River as its own legal entity and directed the Office of the Tribal Attorney to figure out the mechanics of implementing this new law. And so through this resolution, it stated that the Yurok tribe is going to move down this road of codifying the rights of the river that have always existed with the Yurok people, but hasn't been written down in that Western sense of codifying laws. And so we have a lot of conversations about Yurok common law and what does it mean to write that culturally significant understanding of the rights of a river down in a more Western style ordinance or law. And so through those conversations, we found that having a written law that's codifying this general understanding, this deep understanding that the Klamath River has rights. Will support the tribe's efforts moving forward in protecting the river and protecting the living species that rely on a healthy, free-flowing river. And so that's why my office has been directed to start working on this ordinance, and we are continuously fine-tuning and trying to figure out the best ways to move forward to really ensure that this common law understanding that the river has rights can be implemented in a way to provide the strongest protection. We are, as stated, we're working on our ordinance right now, and some of the tasks included in developing this ordinance is legal review, departmental review. So we have our environmental programs, our wildlife programs, our fisheries program. Everyone's kind of contributing to figure out how this law can integrate into how the Yurok tribe is operating and the Yurok tribe's goals for protecting the river. And also through this ordinance process, we are looking at the tribe's enforcement procedures as it currently is and doing a deep dive and seeing like, how is the tribe going to enforce this new law? And what does that enforcement process look like? And what do we still need to develop to successfully implement this law? And so that's adding to the time in creating this new ordinance. But I think it's really worthwhile because we are taking a moment to do a whole comprehensive review to see how we can best protect the Klamath River under this new law. So what is included in this law? First, we provide a strong definition of Weroy, the Klamath River, and how we wanted to be as inclusive as possible of the river. And so instead of just focusing on the piece of the river that's within the Yurok tribe's reservation, we are including the whole Klamath River basin. I provided a map here of the full basin. So as you can see, it's a long river with lots of water involved and a lot of different jurisdictions. So to the north, you'll see there's the state of Oregon. There's multiple tribes within the Klamath River basin. And if you look at the bottom left in the yellow, you'll see that's the Yurok Reservation and then the Hooper Reservation right there. And so our goal is trying to protect the whole river basin. And with that comes its own challenges. We also provide a definition of a cultural riverscape, and this allows us to integrate our law with state and federal laws. And so say we need to bring something that in a state or federal court, we have this definition to support that. The purpose of the law is to not only exercise the tribe's inherent sovereignty, but is to establish rights for the river and to grant the river standing in causes of action against entities that are inflicting harm on the river's rights. And so now the Klamath River can adjudicate its own claims in Yurok tribal court and ensure that if someone harms the river, they can be held accountable. Under our law, we hope to have a clear definition of what the rights of the Klamath River include. As you can see on the PowerPoint, there's some examples that we are hoping to include in the ordinance. We're also going to detail the rights of the Yurok people, and especially the idea that the Yurok people practicing cultural ways of life in relationship with the river are part of the rights of the river. So a Yurok person fishing salmon in a culturally informed way is not going to harm the rights of the river. It's going to enhance the rights of that river. And so having a detailed explanation of how cultural life ways interact with the legal rights of the river is really important to flesh it out. We will also have the rights of the Yurok tribe as a government entity. And then a detailed description about Yurok tribal court jurisdiction, which helps with the enforcement of the new law and ensuring that the rights of the river are respected. So thank you so much for this opportunity to present what the Yurok tribe is working on and the rights of the Klamath River. And please reach out if you have any questions.
Great. I just wanted to thank Geneva for that. And I see we have Guy. in the workshop. Hey, guys.